I'm calling this meeting to order. Welcome to meeting number 23 of the House of Commons Standing Committee on the Status of Women. Today's committee meeting is taking place in a hybrid format pursuant to the standing orders. I'll make a few comments for the benefits of members and witnesses here today. Please wait until I recognize you before speaking. And for interpretation, for those in the room, you can choose on your devices, English, French, or the floor. Same on Zoom at the bottom. Welcome to Ms. Suds to our committee today. And if you want to speak, raise your hand. All comments should be addressed through me. Pursuant to Standing Order 1082 and the motion adopted by the committee on Monday, September 15, 2025, the committee is resuming its study of Section 810 of the Criminal Code and women's safety. I'd like to welcome the Minister of Public Safety, the Honourable Gary Anasangari. Thank you for being with us, Minister. This is an important topic, as you and I have spoken about before. We also have from the Department of Public Safety and Emergency Preparedness, Tricia Geddes, the Deputy Minister, Amy Johnson, the Director General for Firearms Policy, Chad Westmacott, Director General Community Safety, Corrections and Criminal Justice, and from the Royal Canadian Mounted Police, Brian Larkin, Senior Deputy Commissioner. So welcome to all of our witnesses. We look forward to your comments and the questions. Minister, you'll have 5 minutes for your comments and you may begin.
Thank you, Madam Chair and honourable colleagues, for the invitation to speak on the study of Section 810 of the Criminal Code. Let me acknowledge that we're gathered here on the traditional lands and ceded lands of the Anishinaabe Algonquin people. And I also note that I'm glad to be back here. The last time I was here was to discuss the Red Dress Alert, which, as you're aware, is being successfully piloted in Manitoba. In my early days of the practice of law, I advocated for and assisted women and children impacted by violence. Gender-based violence, including family and intimate partner violence, has no place in Canada, and this is something we can all agree on, despite our party differences. Nous faisons actuellement progresser plusieurs.
We are currently advancing several measures aimed at rigorously combating gender-based violence. 2017, the federal gender-based violence strategy was launched, and to date we have invested over $820 million through this strategy. The strategy prevents gender-based violence, supports victims and survivors, and promotes a responsive justice system. The strategy establishes our specific actions within the framework of the National Action Plan to End Gender-Based Violence, which we began working on in a collaboration with the provinces and territories in 2022 and aimed at fully eliminating gender-based violence in Canada. Nous avons également mis en place. We have also established the National Strategy on Fighting Radicalization leading to violence. 21. We've also introduced strong gun control measures such as the red and yellow flag laws to ensure those at risk of violent crimes involving firearms are protected, including in cases of gender-based intimate partner and family violence, as well as stalking. Furthermore, enhanced authorities came into force on April 4, 2025 to ensure anyone suspected of domestic violence or stalking has the firearms license revoked. Likewise, if an individual has been convicted of an offense where violence was used, threatened, or attempted against an intimate partner or family member, they're not eligible for a firearms license. And we're moving forward with the necessary regulations to ensure that if someone is subject to a protection order or peace bond, their firearms license application is refused or revoked. Nous appuyons également. We are also supporting provinces and territories that have adopted CLEAR's law.
Center victims' rights, allowing police to inform persons, current or former intimate partner, if they have a record of prior intimate partner violence, and in turn, ensuring individuals can make informed decisions about their safety. Our government is ensuring RCMP participation in such legislation, including through regulatory amendments. It is important to recognize all forms of gender-based violence, including pipelines that have the potential to radicalize individuals to violent extremism. That is why Public Safety Canada's Resilience Fund supports research and frontline initiatives that work to prevent violent extremism. In October 2025, Secretary of State Sahota announced a federal investment of $36.9 million through this fund, which supports organizations working directly in communities across Canada to prevent and counter violent extremism and gender-based violence. Parce que toutes les personnes
Because everyone in Canada has the right to feel and to be safe.
There's always more work to do. That's why our government introduced Bill C-14, which aims to strengthen bail and sentencing laws, thereby reducing the risk of violence and femicides from recidivism. We have also introduced Bill C-16, which includes consequential amendments that protect victims and survivors of sexual violence, gender-based violence, and intimate partner violence. Women and girls in our country are at disproportionate risk of violence, and our government is working hard to address vulnerabilities and gaps in protective measures that ensure their safety. Madam Chair, my top priority will always be the safety and security of all Canadians, and that means standing up for victims and survivors and preventing violence before it starts. And I look forward to a collaborative approach as we discuss these matters. Je vous remercie.
Thank you, Minister. And nous allons commencer notre question.
We shall start our questions with Madam Diane. You have 6 minutes. Thank you, Madam Chair. Good afternoon, Mr. Minister, with all those accompanying you. Thank you for your time this afternoon. You have presented a positive balance sheet of your activities. We do not agree with all those statements. When we look at figures concerning your government, an 55% increase in crime, homicides 30%, sexual assault 76%, extortions up, car thefts up, car thefts and also on firearms-related thefts have also increased. I think that your intervention is coming in late. Let me come back to firearms, Mr. Minister. You launched your ideological program for the confiscation of firearms. Unfortunately, you are once again targeting sports shooters, indigenous people, and hunters. In Quebec, we have about 300,000 hunters, 3.3 million people throughout Canada. And 91% of crimes committed using firearms are committed using illegal firearms, whereas hunters, sports shooters, indigenous people, as you very well know, are people who have the required permits. Not only there's that, you have provided $750 million for buybacks, first come, first served, and we know to what extent many people will lose money. You also made the statement saying that you do not believe in the program, that if it were to be done again, you would do it another way. And you said you had tried to convince the Prime Minister to do something else and you failed. Are you denying or confirming the fact that you made those statements?
Merci, Madame Vienne, pour la question.
Thank you, Madame Vienne, for the question.
Just address that this program has been launched already. It is launched and available across Canada within the first week. We had over 22,000 individuals who have...
Monsieur le ministre, je m'excuse de vous interrompre.
Mr. Minister, I'm sorry to interrupt you. This is the question. Are you denying or confirming that you said that that program was totally useless? Yes or no? Are you confirming that you made that statement?
False. Okay, so I think you're taking what I've said out of context, and let me just confirm that this program has been launched nationwide. We have, on the first week, over 22,000 firearms that have been registered that are deemed to be prohibited, and there's until March 31st for other individuals to come forward and register their firearms. Let me also say that the firearms that are in question...
Merci, Monsieur le Ministre. Je connais les
Thank you, Minister. I know the parameters of the program. That's not what my question was about. Mr. Minister, many people are against that program, be it the provinces, associations of hunters, indigenous people. Everyone respecting regulations is against this confiscation program. Police corps like Mr. Clayton Candle objected to this program. Are you not just being stubborn with this program? Hunters have written to us to say they invested a lot of money in this buyback program and they will not even get back most of what they invested with this program. What do you tell these people today? Are you going to, clearly the 750 million will not suffice.
The opportunity to answer this question properly. So let me just at the outset say the premise of your underlying question, Madame Vien, is false. This is not about hunting rifles or firearms related to hunting. This is about taking serious firearms off our streets. There are 2,500 firearms that are listed as prohibited. There are over 19,000 available firearms that can be used for hunting. There's ample choice for hunters to be able to pick any one of those firearms and use for hunting purposes. What I would say is that the program launched. It's in the first week we had over 22,000 applications. This program will run till March the 31st. And I would say that we do have a plan, including from the province of Quebec, where the province has signed on to do the collection, and we will be implementing it across Canada.
Monsieur le ministre, la majorité des...
Mr. Minister, let me repeat, most provinces do not want that program. Everyone has said it, that it's not serving them. It's not going to improve safety. How would this program make women safe? Whereas everyone is saying the contrary, even the police force.
Do I have a chance to respond?
25 seconds.
I would refer, Madame Vien, to the Mass Casualty Commission report. I will refer you to Police Savien. I will refer you to a number of civil society organizations, particularly women's organizations that have been working on the front lines, including the National Association for Women in the Law, who have been asking for many decades. In fact, Police Savien, for example, have been working since 1989 towards ensuring prohibited weapons are off our streets, and that is what we're implementing today, Madame Vien.
Thank you so much. Before we go to Ms. Nathan, what I would just remind committee members, the tradition is that however long the question is, we give about the same time for the answer. And so if you want a short answer, ask a short question. If you want a long answer, ask a long question. We'll go to Ms. Nathan for 6 minutes.
Thank you, Madam Chair. Through you, thank you to the committee members and to the Minister for being here today. And I know the ministers are actually busy with many committees, and thanking him for finding time to be here today. My first question is, what is the prevalence of firearms in incidents of intimate partner violence?
It is actually quite startling across Canada. We have, every year we have a number of high-profile incidents involving intimate partner violence. I know in my community several years ago, there was an incident right behind my office, and we see virtually every community across Canada that's impacted by it. The Chief of Police for Halifax is quoted as calling this an epidemic in his region. And it is an area where I think we need collaboration. We need nonpartisanship when we speak about issues around intimate partner violence. The study that you're doing, I think, is critically important. The number of legislation that's before the House, again, is critically important. And as we move to strengthen a number of areas of the law, including victims' rights, by Bill C-16. I'm hoping, we can have consensus that as a country, as a government, as parties of different stripes, we're able to find consensus on what those laws are and move forward.
Thank you. And a follow-up, you spoke briefly about the red and yellow flag laws introduced in the former Bill C-21. Regarding emergency situations and situations of immediate danger of violence, how can those be used to help address the IPV or DV?
Look, there's a number of mechanisms that are in Bill C-21, and they have been operationalized by way of orders in Governors in Council that came into effect as late as last April. We have, again, Bill C-16, again, that speaks to strengthening those measures. Those are long overdue, and they do speak to the ability of law enforcement, the ability of courts, the ability of others who are working and supporting victims to seek remedies by way of a yellow flag, which is a short-term temporary measure, to red flag laws, which are much more longer term and does require a different standard of understanding of what happened.
Thank you. My next question would be, to what extent does policing delivered by the Royal Canadian Mounted Police and First Nations and Inuit communities through the First Nations and Inuit Policing Program support the prevention of and response to domestic and intimate partner violence?
And I'm going to ask Deputy Commissioner Larkin to comment, but I will say that we do need greater collaboration on this piece. I know law enforcement at every level are grappling with this issue, and for many it is their number one issue. So we do need to have better collaboration. I know particularly within First Nations communities, the shortage of resources does lead to inadequate supports. Deputy Commissioner.
Thank you, Minister. Through you, Madam Chair. The RCMP police about 20% of the population, but about just over 80% of the land mass, and much of that is in rural Canada, which does present some significant geographical challenges. One of our goals is to strengthen our approach to intimate partner violence, particularly in our northern territories. And the reality is that also includes a community of whole approach. So we're very supportive of alternative resolution, reconciliation measures, because those communities are very unique, and so the democracy of our judicial system sometimes is not necessarily the best approach or the most applied approach in those territories, and that requires on-the-ground work with our territorial representatives, our community representatives, and it must be a victim-centric as well as a community-centric approach, and that's where our training at Depot in Regina has shifted, and our cultural sensitivity and our preparation for when members deploy out of Regina and respond to remote, isolated communities, our approach is much more focused. But as the Minister alluded, we're currently working on a significant internal Indigenous Inuit strategy to make progressive change, not only for now, but for the years to come. Thank you,
Mr. Larkin, for that answer. I have a follow-up to that. So you've actually answered some of this partially, to have policing approaches to be more culturally appropriate and effective in meeting the needs of victims of domestic and intimate partner violence. So can you talk a little bit about some of the training programs or the education piece that could go with that?
Through you, Madam Chair, very quickly, is that is really the focus of the work that we're doing in our northern territories, as well as some key northern communities. And so our Indigenous policing program very much works with the community, works with Indigenous Inuit associations around various approaches. And the example I'll use is Nunavut, 25 communities. They're all fly-in communities. And so a traditional approach of arresting an individual often requires, and actually requires them sometimes, to leave the community. And so how do we approach community-based intervention? How do we actually approach community-based crime prevention, upstream prevention? Those are the things that we're very much focused on in those particular areas. Of course, in more rural or urban areas where there's a landmass.
That's the end of your time. I'm sorry, Ms. Nathan. This is the hardest part of this job. Maintenant, vous avez la parole.
Now, Madame Laroche, you have the floor for 6 minutes. Thank you very much, Madam Chair. Thank you, Minister, for being here with us this afternoon. Same goes to those affected by this file, because if we amend 810, if we amend the criminal code, which is the objective of this study, we are trying to see what we can do to respond to the rise in femicides and the rise in violence against women in particular. For all these reasons, we thought it was important for the Minister of Justice and the Minister of Public Safety appear before the committee. Many women's groups have been reacting. They have questions. We are not studying a bill clause by clause, but we still have to ask questions that concern some women's groups in this context. Because when these groups hear that the Minister of Public Safety is appearing before the committee to talk about violence against women, we receive questions. So I am like their spokesperson. Like there's a question of strengthening and implementing regulations relating to firearms. There was a bill, C-21, which included key measures to withdraw firearms from the perpetrators of violent crimes. But it's not yet operational, so to speak. For example, one of the measures involved prohibiting people under a protection order associated to violence, prohibiting them from having access to violence. A bill was submitted in March 2025, but women's associations thought it was very weak and asked that it be enhanced because it excluded protection orders associated to crimes. For example, there was also reference to peace bonds provided for in 810, but there's nothing else. So what can you say to reassure these people?
Merci, Madame Laroche.
Thank you, Madame Laroche, for the question.
Look, the number of very important measures have stemmed from Bill C-21, including the yellow flag, the red flag, as well as mandatory license ineligibility and revocation. I would say that Bill C-16, that's again in front of the House, or in the House right now, will address femicide. So for the first time, we're recognizing femicide as a standalone offense, which again, something that many organizations, particularly those working with with those who are impacted by intrapartner violence, have been asking for. There's also additional measures around protection for women as part of Bill C-16. What I would say is, with respect to the 810, one of the gaps that we have is enforcement of breaches, and again, this is something that I think needs to happen in a more robust way. And this is something that, again, I've heard extensively, but I'm also speaking to law enforcement, speaking to Crowns and Defense Counsel and those who represent women. Appears to be a fair bit of a gap in the law. As you're aware, a breach of a 10 peace bond can lead to up to 4 years of incarceration, but is rarely enforced.
Mais somme toute, donc,
concerning this section 810, could you strengthen the regulations so that if there's intimate partner violence, we include all types of protection orders, including those that are under the criminal code?
Thank you. And look, this is something that we will work with Mr. Fraser. I know he's coming next, but I will certainly be willing to work with him to strengthen both the enforcement but also regulations.
donc,
There's also a measure in C-21 that makes people inadmissible to a firearms permit if they are convicted for a crime using a firearm, but it's interpreted as entering into force after application. Many women's groups want it to be retroactive. Why do you want it to be implemented in the future, whereas there are other people in danger already? So to maximize the safety of women, why don't you make it retroactive? Because these are some of the measures you could anticipate.
My understanding is that retroactivity will require a change in the law, and that's not something that I think at this point is in the cards, but we'll certainly be willing to have that discussion with you.
Excellent.
Excellent. Ms. Cody.
The second round.
Thank you, Chair, through you. Thank you for everyone for coming here today as witnesses. It's greatly appreciated, especially you, Minister, for coming to our committee. A few questions. Hopefully we can go through some of them quickly. As the Minister of Public Safety, do you know which weapon of opportunity is specifically used against women in cases of intimate partner violence and homicide?
Sorry, beg your pardon? What's the
specific weapon that is normally used in cases of intimate partner violence and homicide? Do you know which weapon that would be?
There are a range of weapons, including firearms.
And what is the number one?
I am Deputy Commissioner.
You don't have that number on the top of your head, Minister? Well, I can help you. According to the stats I have, 65 to 70%, it says hands contribute to violence against women by pushing, beating, or choking. And sexual assaults are up 76%. So do you know what weapon was used in the murder of Bailey McCourt?
Sorry, what was that?
Do you know what weapon was used in the murder of Bailey McCourt?
No, I'm not aware.
Okay. Well, it was a hammer. So in the death of Bailey McCourt, since it was a hammer that was used, did she die by the actions of the hammer or the person wielding the weapon?
I would say that in many cases, or cases of intimate partner violence, it is an individual that is responsible. There are different weapons that are used in that context. And I would say that it is a combination of the individual who is using the weapon to cause harm on an individual.
So then you agree a hammer is an inanimate tool and can only do harm through the person who intends to use it to do harm? Is that correct?
Look, I'm not an expert, Ms. Cody. I would say that I'm here to talk to you generally about the work that we're doing to
I understand
ensure
that, but can you answer my question? It's a simple question.
Well, if I may, I appreciate where you're going with this, and what I would suggest is that...
Can you answer the question, though, sir, Minister? In all due respect, it's my time, and I think I'm asking a question. Can you answer it? Is it the hammer that does the killing, or is it the person behind the hammer?
It is a combination of both.
So the hammer can act on its own?
It is a combination of both. Okay,
So a hammer can come off a shelf and kill someone?
It is an individual who has the hammer, who can use the hammer in a way that can be very harmful.
So it's the person?
It is a combination of both.
Okay, but the person wields the hammer is what I'm asking you, which is what you're telling me.
Madam Chair, I've answered that question.
Okay. So given that Liberal policy in response to firearm-related violence has been to ban the tool itself, by that logic, as Public Safety Minister, will you be confiscating hammers next?
Again, I'm not here to talk about the compensation program, Ms. Cody. I'm here to talk to you
But it has
in
to
a
do with
broader
public
sense.
safety, sir.
Well, I believe that this issue has been litigated a number of times, and I believe that this conversation,
Okay, that's not answering my question, Minister, so in all due
here,
respect, I'll continue to the next one. Will your Liberal government admit that getting dangerous offenders off the streets is a priority instead of going after law-abiding Canadians with a gun confiscation scam to protect not just women, but all Canadians? Yes or no?
I want to thank the over 22,000 people who registered, 22,000 firearms that were
My question
registered
is to
within
you,
the first
sir.
week.
Are you willing to protect the women and all Canadians by going after dangerous offenders? Yes or no?
It is part of the job that we have.
Okay. So, Minister, a repeat offender who was convicted on child pornography was released early, rearrested for breaking his parole conditions, not once, but twice. He was then arrested a few weeks ago on historic sexual assault, then was granted bail again 2 days ago. This person was well known in Port Colborne. He played the organ in church. He played Santa Claus in community events. And he was a predator. Minister, in what world does the Liberal soft and crime revolving door justice system protect the public or our children? So do you believe criminals have rights when they're committing the crime?
I appreciate the concerns you express, and frankly, there are bills before the House where, if your party stop impeding, can correct some of those examples. I am, frankly, I would say that it is a bit disingenuous.
I'm sorry, that's the end of
Cody?
your time. With all respect, that's the end of your time. We're now to Madame Menard for 5 minutes.
Merci, Madame la Présidente. Merci, Monsieur le Ministre.
Thank you, Chair. Thank you, Minister, for coming here. Thank you to your officials as well. Your presence here is testimony of the sensitivity of your sensitivity to the topics at hand. We are sometimes very enthusiastic to the extent of going off topic. We are talking about bail and sentencing reforms. From testimonies that we heard about the effective but imperfect processes we have. Please tell us about your vision and the vision of the departments when it comes to electronic anklets. Many survivors of domestic violence talked about it. Please tell us what your vision is about that.
Electronic monitoring has very important utility, but it's not without its flaws. So the number of law enforcement personnel and leaders I've spoken to, whether it's on parole or in other circumstances, it works. However, there are limitations. There's sometimes the battery runs out, sometimes it's defective. So it is not a perfect solution, but it is, I think, one of number of tools that are used. I would say one of the more effective tools I have seen was developed by the City of Toronto Police Service, and now I believe it is being expanded across Canada, which relates directly to monitoring. So it's basically a bail dashboard that enables local police agencies to track those who are on bail, for example, and ability for police officers to go to their house or to do random checks, which was not possible just given the volume. So this, in fact, gives a really good sense of what's happening across the city, and if law enforcement's in a particular area, they can go and check on like 2 or 3 houses where there may be people who are on bail.
Merci, Monsieur le Ministre. À la lumière de votre réponse.
Thank you. In light of your answer, we can therefore understand that it's one of the ways through which public safety is trying to protect people. It's not the only means, but it's one of the many tools that are available.
I believe we need to be creative and enhance our tools and to look at alternate ways of doing things. Law enforcement have been driving a lot of the work, and as I say, the work in the City of Toronto Police Service, for example, is one example. But you go across Canada, and I've had the privilege of meeting many law enforcement agencies, and they're quite agile and creative in terms of the work they're doing.
Merci beaucoup. Monsieur Larkin.
Thank you. Mr. Larkin, you mentioned this, but I would like to hear from the Minister. All the witnesses who came here, for example, Detective Auger from the Montreal Police Service, we heard the same thing from the Chief of the Waterloo Service, the same thing from detectives. They said prevention is part of the public safety vision. Could you please tell us more about your vision on this dimension to protect the survivors of violence?
Merci, Madame. Merci, Madame.
Thank you, Chair.
A little bit unique from an RCMP perspective. As I alluded to, our geography and the landmass that we police is very much different from the Service de Police de Montréal and the Waterloo Regional Police Service. And know that service very well. You know, they have an intimate partner violence family prevention center, which focuses on upstream prevention, wraparound service, social services. And I think that, as I alluded to in my previous comments, one of the challenges in the work that we're doing is enhancing training. So when RCMP cadets come out of depot, they have a much more victim-centric, trauma-informed approach. And then when we go into isolated communities, relationship building. The key and reflection of the community that we're providing services to is key because obviously prevention and upstream services, recreation, les services de loisirs, all of those different things play factors into a healthy community. And if we were also to focus on social determinants of health, we'll have a much healthier outcome, which will reduce, quite frankly, the demand on policing. And so I think that, you know, as we look to strengthen Section 810 and the work that this amazing committee is doing, we also have to look at other mechanisms around cultural sensitivities, cultural responses, social and health responses as well for a complete wraparound approach. This is simply will not be resolved through policing, through public safety. It needs a much more stronger approach. We certainly have a role to play.
C'est la fin de votre temps, madame.
Thank you. Your time is up. Madame Larouche, you have 2.5 minutes. Thank you very much, Madam Chair. I have a few questions, Mr. Minister. I hope you answer them rapidly. Let me come back to the regulation organized in March 2025. The women's groups, the National Association of Women in Law, Police se souvient, that have been waiting for more than 2 years that measures be implemented. So in the meantime, women and children have been beaten in their homes. When will those regulations be strengthened and accelerated?
I would say, Madame Larouche, we have brought forward new regulations. As you're aware, we have a March 2025 regulation that is now in effect, another one April 2025, and we're in consultation stages on the other. And as soon as the consultation is complete, we will be able to implement those regulations.
D'accord, maintenant je vais...
Very well. Let me turn to the principle of restraint. Mr. Minister, do you believe that no bail should be allowed if it's a crime committed in the context of intimate partner violence or if it's a serious crime?
What I would say with respect to bail is that we have legislation that's now going through the House. I think the Justice Committee passed Bill C-14 yesterday, and it will be going to the House of Commons for debate and third reading. And there's some very important measures there that does strengthen bail and enable and give greater discretion for or greater authority for enforcement on bail as well.
Very well. We see that there are still things that need to be studied, Mr. Minister. There are groups like Police se souvient that are advocating for the prohibition of assault weapons. There's also an expert group from the government that wants to look into these matters. What will you tell victims that are waiting for all this?
I would say that a fair amount of work has been undertaken, and we have a very divided issue, as you can appreciate. That the comments from the two previous Conservative MPs speak to the toxic nature of this issue.
Time.
Notwithstanding that, we are moving forward.
Sorry, Minister. We're going to move on to Mr. Brock for 5 minutes. Thank you.
Thank you, Chair. Minister, Deputy Minister, Department officials, Deputy Commissioner, thank you for your attendance. Good afternoon. Minister, you took exception to my colleague, Ms. Vienne's characterization of your communication with your tenant. You said essentially that it was taken out of context. without allowing her to continue that line of questioning. So I'm going to correct the record and maybe refresh your memory because I got a transcript. You had a conversation with your tenant, and tenant reminds you, Gary, but we're not the problem, Gary. Gary, I realize that. Gary, if I were to redo this from the beginning, like I'm picking up where it was left off, Gary, listen, I told you if I were to redo this from scratch, I would have a very different approach to this. Tenant, we're talking about Canada. It's a federal. It's not provincial. Gary, I get it. Quebec is in a different place than other parts of Canada, right? And this is something that very much a big, big, big deal for many of the Quebec electorate that voted for us, right? And that's one of the major things. I think I'm sure you've seen these articles where people said, you know, this is one of the things we should not execute, like as a change from Trudeau's policies, but we've made the decision to go ahead. This was all political. Minister, this has got nothing to do with public safety. Law enforcement has consistently told you that from coast to coast to coast, and I would dare say probably in private discussions with the RCMP that they have told you that the problem facing Canadians and victims, particularly women, are not lawful gun holders, but those criminals, those thugs who have easy access to illegal stolen firearms that are pouring into our country. You knew that. You explained that to your tenant. So don't lecture my colleague for saying something out of context. This is something you said, and your points are well taken that this was a political maneuver. This is not going to make people safe. Now, if we're talking to a victim, a woman in particular who lived under a rock for the last 10 years and listened to your 5-minute opening statement, she would awaken and she would say, wow, am I ever blessed to live in one of the safest, if not the safest countries in the world. And you know, Minister, statistically that does not bear that out. So do you have a comment about the fact that your rhetoric does not match the statistics that have been growing literally every single year since the Liberals took power in 2015? What are you going to tell those victims?
Let me first at the outset, Mr. Brock, tell you that when I indicated that I would have done it differently does not mean I will scrap the program. I would have designed it differently. It's a very different set of facts that you're putting forward. Having said that, look, there is a real issue of intimate partner violence in Canada. I'm not underplaying that. I recognize this. I've been to funerals. I've had people in my community who have died because of intimate partner violence. I continue to monitor and see the deep impact that intimate partner violence has in our society. And my responsibility, Mr. Brock, and our responsibility collectively is to ensure the safety and security of Canadians, not rhetoric. So essentially,
my time, Minister.
Brock, you had quite a bit of time.
Minister,
let me just finish.
Excuse me.
Okay?
I would say it was quite a long question. I'll give the Minister 15 seconds to finish.
Okay, so let's work together. And that is my point here. Let us work together. I think what you're misconstruing my opening statements with, you're not reflecting the other work that we're doing in order to address
Minister, I'm moving on. Another theme that you brought up in response to Ms. Cody, that your government consistently brings up day after day after day, is accusing the Conservative Party of obstructing criminal, bail, and sentencing legislation. I don't know where you were at 1:30 this morning, but I was in this building passing Bill C-14. We sat for 9.5 consecutive hours to make this a priority. I then wanted to make a priority of Bill C-16 to get rid of the Jordan issue, to deal with mandatory minimum penalties, to strengthen offenses dealing with intimate partner violence, and every attempt that we brought motion after motion to deal with Bill C-16 as a priority, your government voted it down. So let's set the record straight who really is obstructing their own legislation. It is not the Conservative Party of Canada. You had 7.5 months to bring forward critical legislation to make a difference in the lives of intimate partner violent victims, and you waited literally to the last minute to introduce legislation, and now you're delaying it. Shameful.
That's your time. We will go to Mr. Chen for 5 minutes.
Thank you, Madam Chair. Thank you to the Minister, to the RCMP and department officials for being here today. We are here because we all are concerned about intimate partner, gender-based, and domestic violence. And I also want to provide a quote, in fact, this week from Halifax Regional Police Chief Don McLean, who said that as police chief, I believe I have a duty to victims, survivors, and all citizens to support any initiative that can reduce the presence of firearms in our communities. We know that violence comes in many forms. Weapons of all kinds are used in such cases, but fatal cases more often than not involve serious firearms. Minister, what do you have to say in response to comments like Chief McLean and other law enforcement agencies and police officers who are working hard on the front lines each and every day to stop these horrible incidents from happening?
Look, I want to thank the chief in Halifax. I also want to note that many police leaders across Canada and frontline law enforcement have been working very hard under very difficult circumstances, especially when they're dealing with families and individuals who are impacted by intimate partner violence. It comes in many forms. It comes in coercive control. There's so many different layers to the impact and also the approach that individuals use to hurt others. I would say when we look at firearms as an example, it is one of many issues that contribute to intimate partner violence. And when we have direct evidence on certain types of firearms, based on evidence, expert conclusions from the RCMP, we take advice from them. We, as we continue to strengthen our laws, it will ensure greater safety and security. But the issues around intimate partner violence are also much deeper. It does go to issues around income insecurity, around dependency, the fact that women often make far less than their male counterparts, and a lot of underlying social issues that, frankly, as a government, we've been trying to close the gap on, but it's still a lot more work to do. So it is a much more of a holistic approach that we need to take towards addressing intimate partner violence, and I believe that we've taken some very important steps in that direction, but more still to be done.
Thank you, through you, Madam Chair, to the Minister. I appreciate you raising the issue of socioeconomic factors, and our committee has, in fact, heard from witnesses about the need for education and prevention, as they are key to raising awareness on intimate partner, domestic, and gender-based violence. But in addition to that, it's also about what is being done to support survivors. What actions are the government taking to increase community safety, to reduce violent offending, and to support survivors of these crimes?
Yeah, I think the issues around victims' rights and support for victims is very important, and I think I spoke about Bill C-16. Let me just ask the Deputy Minister to maybe elaborate on some of the programs that we have supporting victims directly.
Yes, so indeed we have made some significant investments in our national office to support victims at public safety, but I think also, Madam Chair, the question was also about offenders and support to offenders programs to make sure that also those the victims are well supported through that programming as well. So there are a number of programs that have been implemented by Correctional Services Canada to be able to ensure that offenders there are provided with programmatic supports to be able to ensure that they are being addressed, but also to ensure that victims of those offenders have also been given those same types of rights and supports that they require.
Thank you very much.
Very good. I think we have just enough time for each party to have 3 minutes to ask questions. So we'll start with Mr. Brock for 3 minutes and then go to Ms. Nathan and then to Madame LaRouche.
Thank you, Chair. Minister, in response to, I think, Ms. Cody's questions regarding the lack of effectiveness of 810 orders and breaches of 810 orders, I believe your commentary, correct me if I'm wrong, was something to the effect that we have a problem not only with enforcement, but also the process in terms of whether the prosecution will continue a prosecution. I agree with you. If the Crown proceeds by indictment, the penalty is 4 years. So in light of that, have you taken the opportunity, and I think the opportunity exists, for you to have regular meetings with your provincial and territorial counterparts? Firstly, do you do that, and how often do you do that?
Very regularly. So first off, when the group as a whole, we had an FPT back in October in Kananaskis. With respect to my provincial counterparts, I have regular conversations. So for example, with Mr. Kersner, I had a conversation today. Minister Ellis, I'm meeting him next Friday. It's very regular, I would say, with most of the provinces, not all, but certainly ongoing conversations.
Sure. As you know, I'm a former Crown attorney. One of the biggest problems that I had was talking to my counterparts across the Canada and seeing major differences in terms of the priority and the process by which offenses that should have not only local but national importance, particularly in the context of this committee, protecting women at risk, is that there is often either police services that just simply don't have an interest in charging under 811, and you have prosecutors who do not want to spend the time to continue a prosecution. So do you think, as a general rule, that there would be some merit in establishing national standards by way Crown prosecutors right across this country deal with IPV offenses generally, but specifically as it relates to terminology in 810 orders and enforcement and how they proceed depending on the fact scenario with the prosecution? Do you see merit, and will you commit today to making that a priority when you have your next general meeting?
Thank you. I do see merit in it, and I'll be glad to look at it further and more deeper, Mr. Brock. I will say that this particular issue would be led by Minister of Justice, so I know he's appearing in a few minutes. So I would pose that question to him. But on the broader issue,
and he's listening behind you, and he's shaking his head.
So we're closing up here, Mrs. Minister. So I'm going to turn to Ms. Nathan for 3 minutes.
Thank you, Madam Chair, through you. To the Minister, I wanted to ask you if you could highlight all the bills that are stuck in committees that are not moving forward, some of them for 8 months, and the bill that they're saying that they have helped pass was obstructed for 6 hours straight. So can you please talk a little bit about Bill C2, C8, C9, C12, C9, C14 that could have actually helped Canadians?
Thank you. And look, first of all, to the previous point that Mr. Brock has made, I want to thank the Justice Committee for the work on C14 and concluding that. Let me also say that there is a need, I think, in Canada right now for greater collaboration and greater ability of people to work together. I mean, Prime Minister Stephen Harper, who you would
be surprised I don't quote that often, has this week made that point or has underscored that point. And what I would say is there's no party that has exclusivity on the safety and security of Canadians and public safety overall. My responsibility, my task as Minister of Public Safety to ensure that law enforcement has the right tools to be able to do their job. So this is where, Bill C-2 is still in the House. That I would say I would implore all parties to come together on passage of Bill C-2 because that lawful access is, in my opinion, and every law enforcement agency I've spoken to have said, that is their single most important tool that they need to be able to do their job. So again, I will end by saying that it is we have opportunities to work in greater collaboration, and I look forward to that bearing fruit in the coming weeks and months.
Okay, so I just want to take the 30 seconds to thank the staff that are here and the minister for making it to the committee and addressing all the questions. Thank you so much.
Excellent. Madame Larouche, la dernière 3 minutes pour vous.
Merci, Madame la Présidente.
Thank you, Madam Chair. Mr. Minister, if I asked you questions a while ago on behalf of women's groups, it's because in Quebec, 6 women lost their lives in the hands of their intimate partners only this January 2026. These are not boding well for the year ahead of us. This is a rise in intimate partner violence that is alarming. It's very alarming, and this requires an urgent response from your government. The 4th femicide was in my region, Shefford, and I extend condolences to the family members of Veronique, the lady who lost her life. So the entire community is traumatized. Mr. Minister, now let's come back to solutions. Do you recognize that Section 810 is often used late? And relying on the comments of Melanie Mele, a friend of the victim, IPVs are some of the most predictable crimes. Do you not agree that Section 810 is not being used late? Can the RCMP make sure that protective orders are respected? Why do we react late when women complain?
Madame LaRoche, and let me just say it's horrifying, the numbers coming out, especially from Quebec in the last several weeks. Truly heartbreaking, and it both makes me sad and angry at the same time. There's some legislative responses that are in front of the House, and I don't want to repeat that, but I would say that we need to have greater enforcement, greater cooperation as issues evolve, and with respect to the 810, I would say enforcement is a key part of it, and if there's a sense that it is being used too late in the process, perhaps that's something that we need to look at deeply. I know the Justice Minister will be able to answer and probably commit a bit more than I'm able to do. But let me just extend my condolences to all those who are impacted by this horrendous losses.
Thank you so much, Minister, and thank you for appearing on behalf of the committee. At this point, that finishes our first panel, and I'll suspend briefly while we bring in the second panel. of Justice, the Honourable Sean Fraser. Thank you, Minister, for being here. This is a very important topic. We know women are dying from femicide nearly every day in Canada, and sexual assault is at all-time highs. So we appreciate you being here. We also have from the Department of Justice, Matthew Taylor, who's the Senior General Counsel and Director General, Criminal Law Policy Section, and Chelsea Moore, who is Senior Counsel, Criminal Law Policy Section. Minister, you'll get 5 minutes for your opening remarks, after which we will proceed to our rounds of questions. So the floor is to you. 5 minutes.
Thank you very much, Madam Chair. Bonjour tout le monde. C'est un grand plaisir d'être ici.
Good afternoon. I'm delighted to be here to discuss this very important topic for our country.
A major priority for Canadians. It's become a major priority for the government, and in fact was clearly demonstrated during the recent federal election campaign with a series of commitments around public safety. But it's clear within public safety there are certain issues that demand that we all as Canadians pay distinct attention to. The scourge of gender-based violence that we've seen in our communities needs to be addressed. Quand j'ai entendu dans le sixième.
I heard about the 6th femicide in Quebec this year. It's unbelievable. We need to take action to fight against gender-based violence every day in every community.
To the specific questions that you may have, and I'll endeavor to be under time so we can save time for those questions. I just want to situate this conversation within the public safety strategy that the Government of Canada has adopted. It rests on 3 key pillars. The first is to adopt stronger criminal laws, including to combat hate, including to reform bail and sentencing, and including to take action on intimate partner violence and protecting our kids against exploitation online and in the real world. In addition to these pieces of legislation, we're taking a broader approach to how we combat crime and to enhance public safety. The second pillar in the strategy in that regard is to make investments in the front line, whether that's new RCMP officers, new officers at the border, or additional supports for community organizations, including organizations that support victims of crime, and including support for women's organizations that support victims of sexual violence and gender-based violence. The third pillar of the strategy in the long term, I view to be the most important, is to make the upstream investments to help build healthier people and healthier communities that will translate into safer communities. This involves a series of investments in affordable housing, supportive housing, mental health and addictions. It involves programs that target at-risk youth. And in the longer term, it involves investments in infrastructure that allow people to live in and enjoy safe communities with access to the recreational and cultural infrastructure that allow them to fully participate in life in their communities. There are a number of bills that are before the House of Commons. I've had the opportunity to appear before different committees. To the extent in particular on Bill C-16, which I expect will go to the Justice Committee, this particular committee is interested in having me appear again to discuss the minutiae of that particular piece of legislation. No, I would be grateful to. In closing, Madam Chair, the first 2.5 years of my career as a parliamentarian, as you know well, having chaired capably during that time, were spent on this committee. It was an enormous professional honor for me to get to work across partisan lines to establish recommendations that were in fact adopted into government policy to help combat gender-based violence in particular. We've relied on some of those recommendations to inform the legislation that I've just described, but I'm happy to hear what recommendations this committee may have in respect of those pieces of legislation, but on the important issue of gender-based violence more broadly. Merci tout le monde, c'est un grand plaisir d'être ici. J'ai hâte de recevoir votre question.
Thank you. I look forward to answering your question.
Sure. Just a word of advice from the interpreters, if you could speak more slowly. And we're going to start our first round of 6 minutes with Mr. Brock.
Thank you, Chair. Good afternoon, Minister. Good afternoon, Mr. Taylor. Good afternoon, Ms. Moore. To you, Mr. Taylor, it feels like it's only been a few hours since we last saw each other. But nevertheless, happy to get C-14 over that finish line. Minister, you highlighted an important aspect that public safety is a priority for this government, led by Prime Minister Carney. I've often said this at many town halls across this country, that the #1 responsibility of a federal government is to keep Canadians safe. And you also reference that you've been listening to Canadians, and I think even in your year-end interview with the national National Press representative, you talked about that the government has been listening very carefully to what victims and what Canadians have been asking for, clearly what stakeholders have been asking for. But this is not, you'd agree with me, Minister, this is not a recent phenomenon. We have known that crime across all spectrums have been rising steadily since 2015. Just some stats to throw out: violent crime up nearly 55%, homicides up 30%, sex assaults up 76%, firearm crime up 131%, extortion up 330%. Canadians are fearful. Female victims are fearful. Intimate partner violence is on the rise. And they are asking themselves, why do I even trust law enforcement? Why do I trust the criminal justice system? That's near and dear to my heart, Minister, because as a former Crown attorney, I took great pride in trying to establish that bond, that rapport with a victim, to give them hope that they were part of Team Justice, to give them confidence that the justice system is fair, responsive to their needs, and would provide a just result. Didn't always get that, but at least they felt that they were heard. So this is something that's not a recent phenomenon. This government, since 2015, has been hearing this repeatedly every year. Since my election in 2021, this has been a common theme that this government has been hearing. So I was very grateful to hear in the throne speech that there was going to be a priority to introducing appropriate crime legislation. The only frustration I had, Minister, and you'd agree with me because these stats would not lie as well. We had the election on the 28th of April. The House opens May 26. Throne speech May 27. Your first crime bill, C9, first reading September 19, 2025, 14 on October 23, 25, and 16 on December 8, 25. So literally, we are now, to this date, 225 days removed from the election, and we have now passed at second reading and has gone through Justice Committee only one, C14. My question to you is very simple. Why did you prioritize C9 when C14 issues, bail, C16 issues, sentencing, and IPV issues have been prevalent for the last 10 years?
Thank you, Mr. Brock, for the question. First, just to more fully inform the record in terms of the crime rates that you've suggested, we did see an increase of crime peaking in 2023, but we have seen those rates are starting to come down. The numbers from 2024 were encouraging, though there is some data yet to be reported nationwide on 2025. The numbers I'm seeing coming in from our largest urban centres are further encouraging, and this gives me some sense of hope that some of the challenges that we've seen play out in communities can be addressed. That is why we not only campaigned on commitments to adopt stronger criminal laws, but have been working over the course of our time since the election to advance laws that are fully informed by those who work in law enforcement and those who administer the justice system. To answer your question on the order of priority, it was not determined that there was one particular piece of legislation that was more politically important than the others. But if you actually look at the complexity of the various bills, C9 is a fairly straightforward bill and was ready when we came back to Parliament after the House of Commons rose for the summer. I spent my summer engaging deeply with experts, people who've dedicated their lives and careers, as you have in your role as a Crown Prosecutor, to understanding the solutions to criminal justice reform that will lead to safer communities. We wanted to get these right, and the endorsements that we've seen on the various bills that we've advanced since then have indicated that we've largely hit the mark when it comes to bail and sentencing reform and gender-based violence. I see you're seeking to get in.
Thank you. I got one further question before my time is up. C9, as introduced by this government, did not seek to remove the religious defense. That has now been a central issue at Justice Committee brought by the Bloc Québécois. You indicated that it was the Justice Committee members who supported that. I can tell you, Minister, that your Liberal members did not pursue any line of questioning in support of that particular amendment. Why did you, at this point in time, several months ago, decide to support the Bloc amendment, which essentially has stalled passage of C9?
Madam Chair, I saw about 30 seconds ago you gave the 30-second warning. How much time do I have to?
I'll be gracious with you. I'll give you 15 seconds.
Okay. The core of C9 that was most important to me was to establish the protections we campaigned on intimidation and obstruction. Through consultation, it was clear that communities facing hate wanted a standalone hate crime to recognize that the harm can reverberate through an entire community. In particular, communities have expressed interest about the role of symbols when it comes to the willful promotion of hate. It appeared to me there was not a path for those core protections to be adopted without having discussions with other colleagues. Now, there has been some confusion and I would say misinformation around the role of the proposed religious exemption. I would entertain further conversations to make clear that we do not wish to criminalize people reading holy texts, their scriptures, attending church services.
Very
we simply
good.
want to protect communities
Minister.
against hate. Thank you, Chair.
It was extra generous.
Yeah,
we'll go to Ms. Nathan now for 6 minutes.
Thank you, Madam Chair, through you. Thank you for being here today, and the Minister as well. And I don't know, Minister, do you want to finish up that question? I could give you time, or are you okay with that?
I've communicated the essence. I'm happy to take your questions.
Thank you so much. So, Minister, here in Status of Women's Committee, we've heard from women's shelters, frontline organizations, and survivors that serious offenses such as intimate partner violence have been strayed due to delays under the Supreme Court's Jordan framework. And many witnesses express concern that victims are left seeing the abuses return to the community because of under-resourced provincial court systems that continue to delay. How do the alternative remedies introduced in the Bill C-16 respects victims, ensures accountability while still respecting the accuser's charter of right to a trial within a reasonable time?
Look, thank you for asking the question. And it's easy to get lost in the statistics on some of these conversations when you look at nearly 10,000 cases being thrown out for delay, when you see cases that sometimes are taking years between charge and conviction. And delays in the justice system serve no one's interests, not the victims, not the accused, not society's, and they need to be addressed. But when you actually talk to somebody who has been victimized, particularly by a sexual crime, who sees their assailant released, not because the charges were advanced, came to trial, and the person was found not guilty, but because the clock ran out, that doesn't feel like justice. I've sat down with people who have moved away from their home province to escape the need to actually live in the same community as their assailant, who is walking freely, despite the fact that there was an evidentiary record being established that may well have led to a conviction. What we want to do to address this problem is cure the injustice that results in a person going free in those circumstances without having the opportunity to have the case fully prosecuted and come to its natural conclusion. The strategy that we've used has a few different planks. First of all, we want to directly address the circumstances in Jordan, because delays were always a problem, but the consequence of cases being thrown out is a more recent phenomenon that followed the Jordan decision. We want to insist that courts consider alternative remedies other than a stay of proceedings that may be appropriate in those circumstances. Now, the facts of individual cases may vary. We want to preserve some discretion for what those remedies may be. But we also want to address the underlying challenge when it comes to delays in the justice system, particularly for complex investigations involving major organized crime, drug offenses, but also cases involving sexual assault. In particular, one of the things that we want to do, not just to increase the timeline by classifying certain cases of complex, but actually streamlining the procedures, for example, how you may adduce evidence in a sexual assault trial, to ensure that the time-consuming applications that are leading to massive delays are diminished as a part of the trial process, so we can have more cases come to their natural conclusion more quickly. This is something that I think will have a positive impact and will result in far fewer cases being thrown out for delay.
Thank you so much for that answer. Some witnesses in our study have emphasized a role for the federal government in bringing together various jurisdictions to discuss best practices relating to both criminal law reform and the administration of justice, which is predominantly in provincial jurisdiction. In the context of domestic and intimate partner violence, including improvements to legislative provisions and supports for complainants and survivors in return to criminal code, peace bonds, and bail reform. How often do you engage in bilateral or federal, provincial, territorial discussions on ways to strengthen the practical applications of the criminal code and associated supports to enhance the safety of women, girls, and gender diverse people?
So the answer to your question is frequently, but with specificity, it would vary depending on the initiatives that we're pursuing as a federal government, or scheduled annual meetings, or on an issue-by-issue basis as things come up that demand a response. I heard the very end of my counterpart in public safety's testimony. I was at the same federal, provincial, territorial meeting that took place this fall in Kananaskis. In addition, as we were developing, in particular, Bills C-14 and C-16, given the breadth of material covered in those two pieces of legislation. I'm sorry, I'm speaking too fast again. We engaged extensively and repeatedly with each of my provincial counterparts. The feedback that they've provided was directly implemented in the bill. I could give examples if more time allowed. In addition to those conversations that we engage in as part of developing new legislative efforts, I will frequently have a touch point with different colleagues. If I happen to be visiting a particular province, I'll often, as a matter of course, set up an opportunity to engage with my counterpart. So it's not as though it's a rigid schedule for each counterpart. It's more driven by what issues we're seeking to deal with collectively.
Thank you. 30 seconds. Don't have a lot of time here. But can you talk a little bit about the federal government can provide funding for the provinces for the administration of justice, policing, and public safety, including transfer payments, cost-sharing agreements, grants, and contributions, and targeted justice programs?
In the few seconds that remain, there are certainly ways that we can contribute to the overall costs, but one of the things that I think is very important in the Federation is that we each understand what our responsibilities are, and we make good on those responsibilities, so the citizens of respective jurisdictions can hold the appropriate level of government to account when it comes time to cast their vote. We all have a job to do, and in a Federation it's important we each do the take care of the responsibilities with which the Constitution charges us.
Excellent. Madame Larouche, vous avez la...
Madame Larouche, you have the floor for 6 minutes. Thank you, Madam Chair. It's true that the last discussion was kind of short because the criminal code is under the federal jurisdiction, and there are lots of things that can be amended now, and the administration of justice falls under Quebec's jurisdiction, particularly on C-16. I know that our justice spokesperson or critic comes from Rivière-du-Nord, and that is something he complained about. It's a good thing to pass laws here, but if we do not have the means to resolve the fiscal imbalance to make sure that Quebec has the resources to administer their justice system pursuant to the Act. If all we are doing is reviewing the Act or laws, but if the people administering the law do not have the resources to do so, then things will change very slowly, or it will be difficult to implement all those measures. Mr. Minister, are you committing to look into how you can ensure that the provinces that are responsible for the administration of justice have the necessary money to implement the new laws that we are going to pass?
Merci pour la question.
Thank you for the question. It is essential to understand the role the federal government plays to change the code, for example, and the role played by the provinces and territories to ensure the administration of justice within their areas of jurisdiction. It's very interesting because C-14, C-16 entailed lots of conversations with the different provinces. The provinces are asking me to adopt changes in federal laws. If the provinces raise issues about changing the law, I expect them to collaborate in providing resources to enforce the changes. But there are issues where there are opportunities for collaboration. There are lots of examples For example, Quebec in C16 proposed the recruitment of young people who commit offenses and cohesive force as well. That is all part of the conversations, but it's essential for the federal government to invest in federal areas of competence, including the RCMP, including the borders, and programs to support young people. You talked about cohesive control. That was one of our requests, and we talked about this when we studied that bill here. I also raised the issue when we talked about cohesive control. Right now, Section 810 ignores cohesive control, which is something recognized by experts. We were hoping that the review of 810 could resolve the issue, but why is this not the case, Mr. Minister?
J'ai juste un problème.
I missed the last part. Could we stop my time so I can repeat the question? I will stop your time. You could go ahead and repeat. Let me repeat. We're talking about cohesive control. Let me repeat my question. And then the current framework of Section 810 remains blind to the dynamic of cohesive control, which has been cited by many experts.
Okay. Merci pour les questions.
Thank you for the question. The details are difficult for me to capture.
The new offensive course of control that we're seeking to establish and peace bonds. And I expect because so many of the circumstances that would traditionally result in a peace bond are actually preceded by a pattern of coercive and controlling behavior. By creating a standalone offense, my hope is not simply that peace bonds will look at coercive control as a factor, but that the justice system will actually start charging people with the criminal offense that we're seeking to create with coercive control. But let me make an offer to members of Parliament, not only with this committee, but others. To the extent that there can be the collective wisdom of Parliament that informs potential amendments to the bills that we have put forward, I'm open to them. I want to consider them in good faith, and if this is an area that their parliamentary study should reveal there is a better way to solve these problems, I would welcome your feedback in that regard.
Okay, parfait.
Mr. Minister, concerning the duration of the commitment, or the peace bond rather, is it possible to review the Act to extend the duration of protection beyond the 12 months in the case of domestic violence?
C'est possible.
It's possible. There was a recent bill at the Senate. I think it's Bill 205 that provides for such a measure. But I think that's a good idea. For this committee or any other committee, it's not necessary to wait for a formal review by the Government of Canada. It's possible for a parliamentary committee to study that issue and make recommendations. It's an issue that is of great interest to my office, so that would be a great opportunity for collaboration. There are a few concerns, a few constitutional concerns.
Length you may look at, but if this is an area that's a priority for this committee, I would invite you to decide to study the issue in detail and provide recommendations informed by expert testimony.
Merci beaucoup.
Thank you. We will continue with Madam Vienne for 5 minutes. Yeah, it's good to hear. We'll be following up on that. Good afternoon to you and your team. First of all, congratulations for your excellent French. It's great to hear that in the sea of Anglophones where we are, so that's perfect. Mr. Minister, can you tell me, between 2006 and 2015, what was the homicide rate in Canada? What was the reduction rate between 2006 and 2015? Can you tell me?
Yeah, statistics. I have memorized them in advance of the committee.
A 10% reduction. The total number of car thefts also dropped by 54%. Sexual assault dropped by 36%. sequestration and kidnappings dropped by 97%, Mr. Minister. That was under the Harper government, under Harper, our esteemed Prime Minister, who was cited by Mr. Nangasari just before you came. Unfortunately, under the Liberal government, the situation has deteriorated seriously, probably because of the laws you adopted. I'll come back to that later. From memory, let me tell you that the homicide rate increased by 30%, car thefts increased by 20%, sexual assault increased by 76%, extortions 330% increase. Mr. Minister, are you able to tell me what is the frequency of women being killed in Canada? How frequently is a Canadian woman killed as we speak?
Tragedy.
I think every 48 hours there's a tragedy. Every 48 hours a Canadian woman is assassinated in our country. This is my question, and it's a very simple one. Don't you believe that C5 on minimum sentences that you adopted and C75 on this so-called principle of restraint, which allows for the least severe sentences to be imposed, don't you believe that these are laxist measures that have placed us in this chaotic situation, particularly for women? And let me remind you that there were 16 femicides last year. So far, 240 women were killed so far, and only this year, 6 women have been killed in Quebec. Don't you think that it is disturbing to come with C14, C16, and then we act as if everything is perfect? It would have taken you 10 years before acting, before realizing that what you did or that what you did not do has led us to a situation where women find themselves in a disastrous situation. I move around on the streets and I'm afraid. We are hyper vigilant all the time. Is that not disturbing?
I expect you and I agree on the severity of the problem and our desire to advance a solution. Conservatives and Liberals and every other party represented in the House of Commons, to a person, I would suggest, recognizes that every femicide is a tragedy and we need to reform our laws. But I think it would be a mistake to point to any particular law or even criminal law reform as a singular issue that would be driving some of the changes that you've cited. Now, I would note that we've seen a positive trend when it comes to a reduction in homicides over the course of the past 2 years in Canada. But I look to one of the laws that you've cited, which actually created more difficult circumstances for a person who's been charged with intimate partner violence to be released on bail. But there are areas of improvement that I think you and I agree on based on your particular question. You mentioned C5. I know that Mr. Brock in particular has been arguing for reform on the principle of restraint. Repealing this, in my view, would not significantly change the law which exists as a result of Supreme Court decisions. But I think we should work together to figure out how we can direct the court to interpret that principle in a way that prioritizes public safety. So to the extent that we can collaborate pour identifier les solutions pour protéger.
To identify solutions to protect women and fight against gender-based violence. That's a good idea. So I will call on you to participate in the process. I don't have any more time. Thank you. You have 5 minutes. Thank you, Chair. Thank you, Mr. Minister, for being here today. Your curiosity and your commitment is appreciated. At this time, we are here in the committee studying the rise of anti-feminist ideology and its consequences on society. Let us start with this. Contrary to what our conservative colleagues are saying, all experts are saying that gender-based violence did not start 10 years ago, but it started with the history of mankind. It's deplorable and it's a sad observation, but we have to collectively work towards eradicating it. with your Bill C-16, Mr. Minister, what you are proposing results from consultations that you carried out with the Department of Women's Affairs, and this was commended by women's groups, particularly because it shows that efforts are being made to strengthen the law, and this is necessary. But we are also working on prevention. When femicides are committed, women are already lost. Women are already lost. Women who will not contribute to the society, they will not come back to work. They will leave their children to mourn them. What can you tell us about this collaboration, which you find essential between the expertise of the Women's Department and Justice? First of all, you are right. The bill is a result of lots of conversations with experts, people who have spent their careers and lives to identify the best solutions to prevent gender-based violence.
Closed doors in talk amongst elected officials. We actually listen to experts in their field. Many of the measures that are included in C-16 follow precisely the recommendations of the Renfrew County inquest, of the Mass Casualty Commission, the largest casualty in the history of my province just a few years ago, the advice of this committee, of the recommendations of the National Action Plan to End Gender-Based Violence. Each of these various sets of recommendations were built upon the same kind of expertise that my department and in many instances I personally engaged with to fully understand the wealth of expertise that exists within Canada on how to address some of these challenges. One of the things that we heard is that criminal law has a natural limit. It typically intervenes only after a harm has taken place. So you need to mirror the criminal reforms with investments that actually offer protections, which is why it's so important to situate this conversation in the broader context of the strategy on public safety. Mais juste pour identifier un exemple qui est une résultat de...
Let me give you an example which is the result of our conversations with experts. There's a new offense of coercive control. It's possible to have the opportunity for the justice system to intervene before violence, before the person is killed. It's not possible to create a new life for the person, but it's possible to create a new offense allowing for intervention before the problem becomes permanent.
When you actually listen to people who've dedicated their lives to identifying solutions, you don't have to reinvent the wheel. You don't have to be the smartest person in the room, but you have to talk to the person who is. And that's the approach that we've tried to take to advance these bills.
En effet, en tout cas, au sein de ce comité-là,
in this committee, the criminalization of coercive control is really what we heard from everyone. It was expected. It was also commended, and we assume that it's going to have a great impact, and we hope that ideally lives will be saved. In a few words, Mr. Minister, words are important. They inform our thoughts. In C-16, we see the word femicide. What can you tell us about that? What is it going to change, the fact that that term was clearly stated in the bill?
Look, I think first it recognizes the severity of the problem. Our Conservative colleague pointed out that there's a woman killed every 48 hours in this country. We need to intervene and have the law reflect the severity of the social problem that we are witnessing in Canada. The inclusion of a constructive first-degree murder charge for cases of femicide would include murder that is motivated by virtue of someone's hatred towards the victim, including because they are a woman. It would include murder that is committed in the context of a sexual offense. It would include murder that is committed following a pattern of coercive control. But it's so important that we twin this new femicide approach to a standalone crime of coercive control. It is important that we punish people who commit very serious and fatal crimes, but it's more important that we do everything we can to prevent innocent people from being killed in the first place. If we can have the law intervene to deal with the circumstances before a relationship becomes violent and before violence becomes fatal, we have the opportunity to save lives, and I think that's something that behooves every member of Parliament, regardless of party, to support.
Merci. Madame Leroux.
Thank you. Madame Laroche, 2.5 minutes again. Thank you very much, Madam Chair. Mr. Minister, let me come back to some issues. Of course, I know that the questions have been asked already. Let's talk about minimum sentences. In C16, we are happy because our bloc position was to restore minimum sentences for serious crimes. That's what we wanted. What has been the impact of the abolition of some minimum sentences when it comes to some repeat offenses using firearms? There are a few minimum sentences where it's not possible to apply the law, where the Constitution is violated.
That we actually move forward with the precise solution that we've advanced was because it follows precisely not only the direction of the Supreme Court on how you could restore mandatory minimums by providing a safety valve, but it also reflects exactly the argument that our Bloc colleagues, Monsieur Fortin in particular, have advocated for in the House, and one of our Conservative colleagues, Frank Caputo, who's repeatedly implored members of all parties to adopt this restoration of mandatory minimums with a safety valve. When we saw cross-partisan support with clear direction from the Supreme Court how you could address that issue, we decided to take action. And with those laws having been struck down, they have no force in effect today. With the adoption of the measures in C16, we can restore serious penalties for serious crimes.
Inaudible. Let's come back to the principle of restraint. I put this question to the Minister of Public Safety, and I put the same question to you. Do you think that there should be no bail allowed when we are talking about crimes committed in the context of IPV, or impose the wearing of an electronic anklet in such violent crimes?
So we have some, generally speaking, I think the expansion of electronic monitoring is a very good idea that can promote public safety. There are two concerns I have with making it mandatory in all circumstances, whether that's mandatory incarceration or mandatory electronic monitoring. The Supreme Court jurisprudence raises serious concern about any mandatory provisions where certain conditions, including not conditions but incarceration, result. You're potentially going to be adopting a law that will be struck down, and I want the laws that we put in place to actually have effect. The second concern around electronic monitoring is actually a very practical one that came from conversations I've had with provincial counterparts. There is a very real resource question about having the court, the criminal code, mandate policy in an area that falls within the jurisdiction of another level of government to determine whether a province actually has the capacity to procure and operate in significant numbers. The number of devices they would need to apply them in every circumstance is something that provinces raise concerns with in my conversations. To the extent we can be a good partner to expand them, I would be supportive.
Wonderful. Now we're going to Ms. Cody for 5 minutes.
Thank you, Chair, and through you. Welcome, ministers, to the Status of Women Committee. Appreciate you coming here today. You stated that there's a reduction in homicide and that rates are coming down. And no offense, Minister, but unless the rates are below 2015 levels, that's not something to be proud of. I don't think women living in violent situations see it that way or appreciate the delays. And is that why the Liberal keeps on filibustering and delaying advancing the laws that would protect women and are continuously putting all these the opportunities and putting on the back burners by the Liberals? So what timeline do the Liberals feel is sufficient to wait while each day women are being killed every 48 hours?
So first, just a comment, then a question. It's a good thing the crime rates are coming down, but don't take this as me saying that the job is done. We have work to do, and I'm going to do everything I can so people can live safely and feel safe in their communities. But just a point of clarification. You mentioned a filibuster. Which filibuster are you referring to?
Last night at the Justice Committee, you were there till 1:30 in the morning, and you keep on accusing, the Liberals keep on accusing Conservatives of obstruction, when in fact it's the Liberals blocking your own bills. In the Justice Committee, it was the Liberals who blocked Bill C-16, a Liberal bill that's supposed to amend the Criminal Code, Acts and Statutes to address child protection.
Bill C-16 hasn't gone to the committee yet. It couldn't be filibustered. It's only been referred by the House.
It's at committee.
But just within the last few days.
Yesterday, yes.
But
night.
There's, sorry, I'm
anyway,
legitimately
so I'm
trying to
asking
get
the question,
clarity.
Minister, if I
Yeah,
might.
but the question wasn't clear. I'm trying to get clarity on what you're trying to get at. There has been no filibuster that you're referring to. If you could just tell which
Okay,
meeting was filibustered
you keep on
over
bringing
C-16?
Bill C-9 to the forefront, and when we have other things that we want to bring forward, the Conservatives want to work with the Liberals to ensure that we are bringing forward bills and laws so that we can protect women, but they keep on getting put on the back burner. So I'm asking you, what timeline do you see is sufficient for the Liberals to move forward so that women can feel safe? Because currently, right now, women are dying every 48 hours. So what is the timeline that you are prepared to offer us today to ensure that you're going to move forward on the bills to protect women?
If you were to give me unanimous consent in the House to advance each of these bills through all proceedings, I would absolutely take it. The problem is that hasn't happened. And with great respect, when I see your colleague, Mr. Lawton, in particular on the Justice Committee, who I quite enjoy personally, but spending hours talking about whether he and his wife prefer puppies or kittens.
This is my time,
you're
and
interrupting every time it becomes uncomfortable when I'm exposing the fact that the Conservatives have been filibustering the committee, delaying the commitments that we
take
Excuse me, please. Point of order from Ms. Nathan, and then I'll make a comment.
I would really like to hear what the minister has to say because I can't hear with all the commotions.
Yes, and I would like to reiterate what I said in the first session, which is like traditionally the amount of time that it takes to ask the question is the amount of time that we would have in the answer, and so the question was fairly long, and so I would offer another 20 seconds generously to the minister.
Thank you. Look, it's ironic that we're even receiving questions about a filibuster rather than questions about how we can better protect women against crime and combat gender-based violence. If you actually go back and look at the videos, you'll see that it was the Conservatives who were talking about whether they prefer puppies or kittens. That said, I think there's a broad base of agreement on gender-based violence, on bail and sentencing reform. I think we should let other issues where there's disagreement go to a vote so we can all practice democracy rather than interfere with the agenda Canadians.
All right, and back to Ms. Cody.
Okay, Minister, I'm going to ask a question that I asked the Minister of Public Safety. He wasn't able to answer. A repeat offender who was convicted on child pornography was released early, rearrested for breaking his parole conditions, not once but twice. He was then arrested a few weeks ago on historic sexual assault, then was granted bail again 2 days ago. This person was well known in Port Colborne. He played the organ in church, he played Santa Claus in community events, and he was a predator. Minister, in what world does the Liberal soft and crime revolving door justice system protect the public or our children? So I'm asking you, do you believe criminals have rights when they're committing crimes?
Look, I'm struck by an incredulous nature of that question. Rights exist in this country, but we can also agree that dangerous people who commit serious crimes should be incarcerated. We are literally changing the law as we speak to make it harder for violent repeat offenders to be released on bail and to face tougher sentences. I think that's something we agree on, but the combative nature of this exchange and, frankly, the position of parties in the House on matters where we should be finding common ground to advance policy is a reflection of a sorry state of Canadian politics in a lot of ways. So I'm not going to stand here and say I support this egregious behavior of a predator who's committing crimes. No, that's someone who should face real consequences for very serious infractions. But we can't just bluster at committee with aggressive talking points. We need to identify solutions, debate them, and advance them so we can actually offer protections to people and communities. If you want to see
Minister,
that outcome as well, I would welcome your collaboration.
By now.
Actually, all of your time is up.
Okay.
And so we'll go to Mr. Chen for 5 minutes.
Well, thank you very much, Madam Chair. We're all very alarmed by the statistic that every 48 hours a woman or girl is murdered in this country as a result of gender-based violence. Feminicide, as the Minister knows, is rarely a random act. It is most often the culmination of patterns of control, coercion, and violence against women. So through you, Madam Chair, to the Minister, how does recognizing these murders as first-degree murder potentially better reflect the realities of gender-based violence?
Well, Symbolically, it places it as amongst the most serious crimes that can be recognized in the criminal code. Practically speaking, dealing with life sentences without a chance of parole has a substantive impact on the actual sentence that an offender is going to receive. But what I think the additional value it provides is demonstrating an understanding of how gender-based violence actually takes place in an intimate partner violence context in particular, and in society more broadly. You're right to point out that it's not as often that there are just random acts of violence, though it may happen and sometimes at a scale that is tragic and beyond imagination. If you don't believe me, talk to our colleague, Minister Provost, in this regard. But when we can actually listen to those who've studied their entire lives, sometimes have lived experience that they can shed a light on these issues, you'll understand that it often follows a pattern of predictive behavior that would allow us to intervene before a person is killed. When we see that there is a significant number of crimes that are murders rather that are committed that are motivated by hatred towards women, we need to take action. When we see that murder too often takes place during the commission of a sexual offense, we need to take action. When we see that murder takes place often following a predictive pattern of coercion and control within an intimate partner relationship, we need to take action. But it's not enough if we simply change the law to offer more severe penalties after the murder has taken place. We have to do what we can to prevent that harm in the first place as well. I heard that loud and clear during my consultations. It's part of the reason why we included a standalone offense of coercive control in the bill, but it's part of the reason we continue to remain committed to the National Action Plan to end gender-based violence and want to put systemic investments in place to help ensure people have protection in their communities and that we build healthier people in the long term to reduce violent crime as Canada's history marches forward.
So it would be fair to say that Bill C-16 seeks not only to punish the most serious crimes more appropriately, but also to name and confront the systemic nature of violence against women. Minister, in November 2025, this committee published a report on coercive control following extensive testimony from survivors, experts, and law enforcement. We welcomed Bill C-16 shortly after in December 2025 as a direct response to that work. And during that study, witnesses at this committee told us that coercive control is often the most dangerous phase of intimate partner violence, yet it is frequently invisible to the criminal law until physical violence occurs. How does Bill C-16 allow the justice system to intervene earlier before harm escalates?
At risk of repeating a point that I've made previously, a standalone offense of coercive control has the opportunity to intervene after a pattern of behavior that we know has predictive value that's more likely to result in a person being killed. If we can actually establish an offense that allows the law to intervene before physical violence takes place, or perhaps before violence turns into deadly violence, we have a responsibility to offer those protections to people. But in addition, there's a number of other changes that we've made that are not just about coercive control, but nevertheless reflect a very serious trend around crimes committed against women and communities that often have lasting and traumatic experiences. Look at the modernization of the criminal harassment provisions that allow us to more easily charge people, which is also often a behavior that precedes more serious physical violence. With 30 seconds left, I'll point only to one other measure. We're seeing modern technologies being used in ways that were not imagined when the existing rules were written. I'm thinking not only about the changes to criminal harassment using new technology, but also about the non-consensual sharing of intimate images and the use of AI deepfakes. We need to continue to recognize the lived reality of women who are facing violence in this country and continually update our laws as practices and technologies change.
Excellent. I think we have enough time to do what we did on the last panel and have 3 minutes for each party for their final questions. So, Mr. Brock, to you for 3 minutes.
Thank you, Chair. Minister, you were in the back of the room when your colleague was questioned by this committee. I had raised questions regarding your meetings with provincial and territorial counterparts. The question I'm going to put up front and then the justification to follow is what steps are you and your government taking to restore trust and confidence that is sadly lacking by intimate partner victims in this country, particularly women, who feel that we don't have a justice system, we have a legal system. There's a lack of trust and confidence in policing. And when substantive charges on the 810 issue, when substantive charges, whether they be assault, whether they be threatening, whether they be mischief related of a domestic context, are simply withdrawn and with an urging to accept an 810 resolution with zero enforcement and zero consequences contributes to that lack of trust. Will you commit to ensuring national standards right across this province with your provincial and territorial attorney generals to ensure that their Crown policy manual sets out a basic direction as to handle domestic related cases and a direction with respect to under what circumstances will a charge be withdrawn in favor of a Section 810 charge and what instructions you'll give for enforcement under 811?
Thank you for the question. I've got less than 1 minute, so I won't have time to answer the systemic trust preamble that you've put to me. On the specific question of provincial collaboration on 810 and violations under 811, it strikes me as a good idea, but I would need to have conversations with my provincial counterparts, and I would need to do a deeper study, having only had this put to me when my colleague received the question. The one caveat that I would put to that is I would want to insist, whenever you're dealing with criminal remedies, as you would well appreciate, Larry, they're highly fact-dependent and individualistic. To the extent we can ensure there's the ability for the court to have remedies that fit the facts of a given case, which will adjust. I do think guidelines and consistency across the country is generally a good thing, but I would certainly demand the opportunity to engage with my provincial counterparts before I broadcast in a live meeting that I'm going to do something that I have not consulted on.
Thank you, Minister.
Wonderful. Madame Menard, 3 minutes.
Merci, Madame la Présidente.
Thank you, Chair. Mr. Minister, this is our last round. When you came up with C16 in collaboration with judicial, social, judicial, and community stakeholders, you took into account the sad testimonies of victims and survivors who recounted their experiences in the justice system that left even more scars. Are you able to propose measures taking into account the courage that is required of these survivors to engage in any denunciation? What measures have you implemented through C16 to avoid re-traumatizing the survivors?
So maybe first, there's not a measure in C16 where I haven't spoken to a person who's lived through the reality that would have benefited from their protection. These are the most human set of policies you can imagine, particularly when you're dealing with sexual crimes where a person's bodily integrity has been violated by an assailant. The point you're making on re-traumatization is very real, particularly when you're dealing with just think about a person's experience. You may talk to your friends in the first instance when something happened, which can be difficult. You may report it to police who may or may not believe you. You then have to go to a Crown prosecutor and are potentially going to tell the same story again. You may have to be cross-examined in court. You may continually be faced with people who question very deliberately your integrity, your version of events, and it can be very traumatizing for the person. We in particular wanted to address clarity in the changes to the Victims' Bill of Rights to minimize the traumatization that a person goes through. This can include testimonial aids that a person can benefit from. It can include information that they're entitled to. It can include the right to participate through different parts of the trial process, whether that's a victim impact statement or even after a person's been convicted and might be transferred from one level of security prison to another. We've done everything that we can to listen to folks who've studied these issues, who've come up with recommendations, not only how to promote public safety, but it can improve the experience of a person who's gone through life-changing and traumatic circumstances as they seek to see justice done in their individual set of facts.
Merci, Madame.
Thank you. Madame Larouche, your turn, 3 minutes. Thank you, Madam Chair. Thank you once again, Mr. Minister, for coming here today. As I stated before, To your colleague, the figures are startling, so we need to take action. Furthermore, concerning judicial deadlines or delays, that has been a concern that has been cited by the victims and survivors over time. The Jordan Principle delays has been raised. A bill was submitted to look into the Jordan Principle. So in C16, do you think that the measures would suffice to prevent perpetrators who are released because of these deadlines? I think the bill presents an opportunity to improve the situation and make a difference. Hopefully, there could be exceptions, but generally speaking, it's a good thing.
There are two distinct issues. One is delays generally, which are an injustice to the victim, to the accused, and to society. The second is the consequences of the Jordan decision, which result in those delayed cases being thrown out when the time runs out. We want to address both of those challenges with procedural changes that are going to improve the pace at which cases move through to trial and potentially a conviction where warranted. But we also, in the intervening period before that delay is fully addressed, want to change how courts deal with circumstances that exceed the recommended timelines in the Jordan decision. Specifically, we want them to consider remedies other than a stay, to have fewer people be released without their charges coming to a conviction. We want to ensure that we more clearly define complex cases to understand when certain kinds of cases should be treated as more complex, benefiting from a longer period of time.
Thank you so much. I'm sorry, that's the end of the time. Minister, on behalf of the committee, thank you so much for appearing today. You can hear the urgency of these issues for women. So before we leave, folks, the minister had mentioned Frank Caputo's bill, which is coming here, and you received the budget for $16,050. Is it the pleasure of the committee to adopt that budget? Yes? Very good. And then with that, I will, one more thing, Madame Menard.
Madam Chair, I would like to submit to the committee the possibility of changing the date to the 20th of February, recommendations regarding amendments to give everyone enough time to react, because right now they are due on the 25th and we are meeting on the 26th. So this is a very tight deadline. So I'm proposing to members of the committee that we react and send our comments on the 20th of February so that we don't end up with only 24 hours.
Extend that deadline? They are disappearing before my very eyes. Is it the pleasure of the committee to extend the time for recommendations to be the 20th? Yes? Very good. So ordered. With that, I'll adjourn the meeting.